this is the final panel. You want to know what holdup is. Does it exist in real life? Yes, it's this panel between you and the cocktail hour. But in order for us to sort of build up to cocktail, we need to engage. And so this last panel is going to hopefully be one where we have active engagement of all of you in the audience with all of our wonderful panelists here. Some thoughts. It turns out over time we've seen best practices across a number of different areas of competition law emerge, both on process and with regard to substance, moving towards greater acceptance of economic analysis. So I'll give a few opening thoughts and then we'll move to our panelists. So what's fascinating to me is that, for example, in the United States, the jurisdiction I know best, what we have is a situation where in our own Constitution, due process concerns are a fundamental part of our legal system, in fact, embedded in our Constitution. We also have this in civil law countries, in other common law countries. What's fascinating to me, however, is if you look globally at best practices, we technically don't have a best practice for procedural fairness, both due process and transparency, and largely the holdout seems to be the European Commission that worked very hard against any kind of really strong practices with regards to the ICN work, limited both the scope of where it would be and also what could ultimately be said. And I'd like to say that this seems to have been the only incidence, but it wasn't. Just recently, my understanding was Competition Day in Estonia. We also got some murky comments that didn't really get to best practices. This seems like Europe is out of touch. So if this is leadership, IP, from my perspective, I'm not seeing the kind of leadership that I would expect from DG Competition. And so typically, when you don't see transparency and due process, you get concerned because you're saying, what does somebody have to hide? And this gets to the second point. And we saw some of this in our last panel with regards to economic analysis. So it turns out, if we go with the rhetoric that has existed, certainly at least since the time that Mario Monti was the commissioner, we got the language that this is effects-based, this is consumer welfare-based competition in Europe. But when you lose a case, as we saw recently in Intel, we get a reframing of, well, maybe this is just a narrow procedural case after all. Maybe it's just about effects in this particular case and not about the whole system. So on the merits of the specifics of Intel, I think from an IP perspective, it's not so important, but there's a broader meaning, and hopefully we'll be able to get some analysis of what that looks like. What I could talk about from the US system is what happens when you lose cases. So the US Federal Trade Commission went through a period of time where it lost 7 cases in a row specific to hospital mergers. And instead of saying, it's not us, it's the judges, it's not us, it's the procedural rules, it's not us, they don't understand the evidence, there was a real sense that you had to really go back and think, what are we doing wrong that we don't seem to be winning cases? And there was a lot of soul searching and trying to figure out how to create a case where the facts matched up to the theory, where you could show the negative economic impact of hospital mergers, and after that, the commission started winning these cases again. And it takes a certain amount of humility on the part of an authority to understand that you have to match up rhetoric with reality. And we see these kinds of practices, this soul searching, across a number of jurisdictions. So I'm not going to say that the United States is even the best, for example, in transparency and due process. I'd probably say that's Brazil. That's probably the most transparent competition system in the world. On economic effects, a lot of agencies around the world take it seriously and really mean it. In the States, we've essentially had, at this point, just about 40 years where this has become the fundamental concern. So it's not fair relative to other systems. But when you talk about the importance of effects and don't actually see the importance of the effects in decision making, it chills very important investment. We saw that in our first two panels, what the negative implications might be. Now with that, I thought we'd start first with Luis, then go to Paul, then go to Pedro. We'll have a little discussion, and then we'll get all of you involved, because again, if you're not involved, I'm going to keep you here longer, and then you don't get the benefit of the, yes, free alcohol. So I'm aligning incentives, hopefully. So with that, Luis, I'll turn it over to you.
Thank you, Danny. I've been asked to speak about the implications of the Intel case on how practitioners in Europe view issues of economic analysis, comity, and procedural fairness. And I'm going to do just that. I will try to be brief. So beginning with economic analysis, the debate on what the actual judgment in Intel means is a heated debate. The issue is whether the Commission has won or has suffered a defeat. Well, I guess that, as usual, it all depends. And this time it depends on the meaning of the judgment. There are some possible interpretations to paragraphs 138 and 139, and also 136. If Intel goes to the substance, and if the sufficient competitor test is to be examined in every abuse in pricing practices, we could assume that, speaking in standard language for Article 101 cases, we've gone from a per se perspective to a rebuttable presumption. So there will always be an opportunity for a defendant, for a respondent, to make a claim that that particular competitor is less efficient and it shouldn't be protected. Well, this opens the question whether less efficient competitors deserve some protection or not, in general, and whether these protections should be granted in the face of loyalty discounts or in the face of any kind of practice dealing with prices, which may have an effect on the outcomes in the market, or in the face of any possible abuse. Everything is being debated now. The Commission, DG Comp, is still reflecting, although we have already had some feedback from some of the high officials there saying that there is no problem with Intel because, in essence, it's a win. But that's not the view, of course, of many people who have been involved in the Intel case. Now, the second issue I've been asked to talk about is comity, and there I think there is a clear win for the Commission, and that's why I guess comity is relevant in this context, because once the court has construed so widely the jurisdiction of the European Commission and public international law, there is need to be proportionate, there is need to introduce some kind of prudence, comity you call it under public international law, to avoid encroaching in other countries' jurisdiction. Given the very wide jurisdiction that has been established under the qualified effect test, as applied by the European Union courts, there is definitely a need to use comity to avoid problems with other countries. Third, on procedural fairness, I think that here the Commission has suffered a clear defeat because in this case, the practice of distinguishing between different types of meetings, different types of Article 19 interviews has clearly been criticized by the European Court of Justice. Here you may know that the Commission had a meeting with one of the companies that had been offered and granted loyalty discounts. This was a meeting of 5 hours. The Commission did not make a sufficient record of the meeting. It provided some kind of redacted internal memo, and the court has said that's not enough, and now the Commission must record, in whichever way, any meeting it is having. There is no possibility in principle to make Article 19 interviews informally. Now this has some possible side effects. First of all, one could guess that given the more cumbersome handling of meetings, the Commission may be less willing to have meetings with respondents, with interested parties in general. This is something that might happen just for administrative reasons. Not that the Commission is willing to deny rights to anybody, but it is much more difficult now than it used to be to meet with someone who's interested in the file and who's possibly providing interesting information. Now, there's also the possibility, and there is one mention to that in the judgment, that there are many more requests for witnesses to be heard before the General Court, because that's one of the things that was in the judgment that the Court of Justice said that Intel could have done. So probably no one is going to miss the opportunity to call witnesses before the General Court, and it might be more difficult to deny that happening in the future after Intel. So in sum, as to procedural fairness and to procedural issues, the Court is effectively expanding the rights of the defendants and respondents in EC procedures. The European Union procedural standard has been enhanced. There will be more transparency, and that's the good news. And I would close with one point. That's the natural evolution under European competition rules. Under Regulation 17, in the beginning of its application, in the beginning of the enforcement of then Articles 85 and 86, the rights of the parties were much more limited. The practices, the administrative practices, were much less generous towards respondents than they are now. The standard in the European Union is getting better, although we might discuss later on whether it is sufficiently good and whether it can actually be improved. That's all I had to say.
Paul, in addition to being a well-versed practitioner in a law firm, you have a prior experience in-house, and both of those lend themselves to very important work that you've done with the International Chamber of Commerce. In many ways, you're uniquely situated to really work through these issues because you've seen both how the business unit deals with these issues and then also how you deal as a process side as defending clients.
Thank you. Well, just coming back to something that you mentioned earlier, and that is the leadership role of the Commission. Now, there are so many agencies these days. Many of us have started your work, your career, when there were 20, maybe 30 agencies. These days there are, I believe, 130, more than 100 countries, 120 countries part of the ICN, and that creates a real issue. I fully agree with Luis with what you just mentioned about due process in the European context. And if you read especially the parts of the judgment on the informal versus formal interviews that the Commission held with, I believe it was a Dell employee, which was critical for the case, and how the Commission tried to deal with that, then there is a real issue and a real concern. Now, having said that, and that, coming back to your point, that is a critical point because the Commission does have a role to play as a guider in this new constellation with so many agencies. So that makes it extra important that the Commission lives up to these due process standards. But I wanted to shift the focus a little bit to other jurisdictions, especially in light of all the agencies that are now coming up. And I'm trying to get some slides up, and here they are. So I wanted to take you to the world of the ICC, which is the International Chamber of Commerce. In my spare time, I had the Competition Commission, and that Competition Commission has issued a new guide on due process. Now, this is a very general guide. It applies to all kinds of investigations conducted by agencies, but I believe that there is a specific relevance and importance to IP-related issues. Essentially, what ICC has done is it has updated and expanded the existing work on due process, and we hope, of course, that gradually these due process best practices will be implemented by agencies. So I'm sure we'll talk about licensing and IEEE and maybe other things, but just a little sidestep into best practices generally. So why are due process principles, procedural safeguards, rights of defense important? Well, first, they discipline the agency and make sure that the agency arrives at better and more consistent decision-making. There's more accuracy, and it ensures the focus on what is important, and that should be long-term consumer welfare. There is another thing which sometimes is forgotten, and that is that if agencies comply with due process, then it will enhance the entire system. It will enhance the legitimacy of the competition regime world generally, and that's a good thing. Now, I mentioned a couple of things which are important and which are recognized in various degrees of intensity in existing materials. Due process is about the proportionality of the use of investigative powers. It's about information rights. It's about access to file, the right to be heard, the opportunity to make comments at an oral hearing. Many of these things are very well known to you. There has been important work by the OECD, important work by the ICN itself, but also by agencies. And then in addition, there's obviously the ABA and now the ICC who have contributed to that debate. But having said that, there is still a lot of uncertainty what it means in practice and how these best practices must be implemented in practice. And the ICC best practice guidelines have attempt to make that explicit. Now let me briefly say something about why is this all important for IP-related matters. Again, many of these principles, all of these principles have a general application, but the important thing is that in some of the IP-related cases, the consequences of a bad decision by the agency are irreversible. So, and that may also happen in other cases, but I think IP is one of those areas where these consequences are potentially particularly irreversible. Now, you may then say, well, yeah, but you know, parties can ask for a stay. Well, we all know that the threshold for interim measures or a stay of a commission, the enforcement of a commission decision is very high. It's very difficult to make that happen. But there are two cases two judgments rendered by community cases specifically dealing with IP cases where the court has said something about the consequences of a negative commission decision. And those cases are McGill and IMS Health, both relating to refusal to deal. And in both cases, the commission had found in violation, and the parties had then asked for a stay. And in both cases, the court said, well, actually, in this particular case, the consequences might be so severe and irreversible that in this particular case, a stay of the proceedings, a stay of the enforcement of the commission decisions is warranted. So there is something specific about IP cases, not in all the cases maybe, but there is some growing awareness that there must be something which is specific to IP cases. And if the consequences are sometimes irreversible, then to me that means that respect for due process is even more important in these cases, because you cannot necessarily get a stay. So this is, I think, the specific importance of IC or other best practices for due processes. So here's the screen print of the guide. It's downloadable for those of you who are interested, and it does what it says. It sets out principles that agencies should comply with. Let me just move to a number of things that some of us have seen in practice. So those are examples of common antitrust due process failings, and one of them is a refusal to grant effective access to the file, and that happens in many different shapes and forms. And one of them is that the agency will agree with complainants or with third parties that their identity will not be made public, or that the information that they have given will not be made public. So there's an over-inclusive confidentiality request which is granted, and that doesn't help a party to respond to the concerns, to the complaints. And there is a corresponding ICC best practice which states that access to the complete case file, etc., etc., etc. So that's one example by which the ICC best practice seeks to focus on the actual implementation of, in this case, access to file. Insufficient time to respond to allegations. We're involved in a case in which there is no SO or any similar document, but in which the agency submitted a draft decision 5 days before it actually rendered the definitive decision. So this was the first time that the company actually found out what the real concerns were, but it had only 5 days to respond. Now, there is an appeal pending in that particular case, and by the way, it's not a European case, in which a number of documents are now surfacing which have not been made public or not been made available at all during the investigative phase. So that's another example. There are cases where only during the oral hearing parties are coming up and are confronting the company under investigation. And finally, there are cases where there is no meaningful interaction, no meaningful exchange of views with the agency. Corresponding with the agency does not mean that there is an exchange of views on the nature of the complaints, the theory of harm, and all the crucial elements that a party needs to know in order to defend itself. And then let me just skip to the final one. We have an issue with agencies that are too easily embarking on investigations, sometimes inspired or fueled by national industries or companies that are well situated in that particular jurisdiction, and then the investigation never ends, and that's a growing concern. It's very annoying to know that there is an investigation going on. That investigation may anytime result or culminate in a negative decision. Companies need to think about their exposure, they need to report to their stakeholders, and it's just one of the most annoying things that happens. So there must be some discipline on agencies to not only critically review, well, do I have enough information to objectively start an investigation, but also, if there are no prima facie concern after a certain time, to stop that, to end that investigation. There is a side effect there are a number of agencies that are actually obliged to come up with a decision, I believe, after 10 months of starting the investigation. And that may also have a negative effect, namely, if the agency is not ready, then you might be faced with a decision which is not well reasoned, etc. So there's a plus and a minus there. But the main point is agencies should be very careful in not only starting but also ending investigations. So this is, Danny, what I wanted to say about these international due process principles. They have been presented to the international competition community at the ICN conference in May in Porto. Surprisingly, there were a lot of agencies who were very happy with these. We also have consulted with the Commission and other agencies before we decided to issue these. And again, I hope that gradually over time these principles will be implemented.
Thank you, Paul. Hopefully everyone who's a practitioner in the audience looks at a number of these due process points. I'm just going to go back to that. And immediately these principles resonate because in our own ways, we've all had this experience. At least in one of these three, if not all of these three areas. I want to move now to Pedro. So it's fascinating because if this is a panel on antitrust developments, why do we have an IP and trade lawyer on? So the cynics among you would say, well, I'm an IP lawyer, and I thought that all these issues that we've been talking about earlier today were IP issues, and I find out that, these are competition law issues. So for those of you who are cynics, I say, we're going to have it right back at you, because we're going to say, even in competition law, we should have some humility and learn from other disciplines that are dealing with exactly these kinds of concerns, but in different settings. So we have a public international law interface, and Luis also touched on that in the context of comedy, but then we also have procedural concerns with regards to transparency and due process. And it turns out, both on the trade setting and the IP side, you've also had to address these kinds of issues in your negotiations across a number of different jurisdictions with very different legal systems, with many different parties saying, but we're special, these rules shouldn't apply to us. And yet, from your side of what it means to be a negotiator on behalf of Europe, actually, these are core principles. So with all of that, Pedro, enlighten us about what trade in IP could actually teach the competition community.
Thank you very much, Professor Sokol, for your introduction, for explaining. Indeed, it's not very obvious why I would be here. You saw I was asked to come here and to remind you that there is a world outside of competition. And this suits me just fine, because I'm most certainly the person in this room that knows less about competition. But I know a bit about trade and IP, and these issues on occasions cross their paths with competition. And it's certainly very interesting to see what we could each other learn from that. So we, on the IP world, our cliche is that competition people, they have a problem with these concepts of intellectual property. Concept that deals with exclusive rights, temporary monopolies. This all sounds a bit like an heresy, and therefore competition people, they don't really understand our concerns or the perspective of intellectual property right holders. And occasionally these differences of perspective, even if they are put here as cliches, they cross and they may clash. I have been on IP for a number of years, 13, 14 years around, and the first time when I came in practice to a situation where there were different perspectives was when our colleagues in DG Competition, there was at some stage, in some cases, there is an inter-service consultation. And on this case, there was a question about defining what was an unwilling licensee, and to see how do you define it, and the consequence being where it would depend on this to know when it would be possible then for the owner of the patent to trigger an injunction or a provisional preliminary measure in a case linked with standard essential patents. So this is how we came to it, and we had very interesting debate at the time, because on our side we reminded our colleagues that countries having in place provisional or interlocutory measures is a legal obligation according to the rules of the World Trade Organization. The TRIPS agreement sets this obligation and does not make a particular exception for competition cases or for standard essential patents. So we had to somehow there find a way and to set the right balance. One that would ensure that competition would be safeguarded, but one that would not lead us into some kind of infringement at the World Trade Organization. It's an area where there is dispute settlement, so if you are infringing the rules, you can actually be punished for that. So that is how we started. This took me and my colleagues in the team for the first time into this extremely interesting area of standard essential patents, where we since then have been very active and seeing constantly this link between intellectual property and competition law. This is a global issue. It is an issue that from the trade perspective affects our European stakeholders, both the ones who are implementers and the ones who are innovators, in a number of third countries. And because there is this IP angle, we have started to discuss these issues with our partners in several countries. In the United States, in China, in India, in Korea. Just last week I was in Seoul, maybe not the smartest place to be at the moment, but we had a dialogue in intellectual property, and we had a very interesting conversation about these issues, where our point was exactly that when you look at the cases of standard essential patents, you also need to have in mind, even if they are being addressed by competition authorities, it is essential that you have in mind that there are other kinds of issues and interests that have to be measured and that are equally in the public interest and in the interest of the society and the consumer. And one of them is how to, for instance, keep these standards attractive to innovation. So there, and one of the classical mechanisms to attract and to promote innovation, if it's done, of course, in a balanced manner, is intellectual property, and patents are examples of that. So these are the kind of issues that we discuss from a trade perspective. We also, it's very important to have in mind that some years ago, already in 15 years ago, maybe more, there was an attempt to bring competition into the multilateral framework. At the time, I believe it was called one of the 4 Singapore issues. And with the difficulties, the failure of at the time, Seattle round, and attempts to relaunch the multilateral process, in the end it was decided that the multilateral setting was not mature enough for a multilateralization of competition. But in the meantime, several main trading powers like European Union and others have moved a lot to bilateral trade agreements, And there are rules, quite a developed chapter on intellectual property and maybe a not so developed chapter on competition. But then there are these kind of rules and principles of equity and fairness and equal treatment of the parties. There are also mechanisms of dispute settlement that are present, and these are state-to-state dispute settlement. There is also another angle, quite a complicated one, and that is relatively new for European Union, which is investment agreements, which traditionally and there are thousands of them that exist in Europe. They also contained a system of investor-to-state dispute settlement, so dispute settlement between private entity and a state if their investments were at risk. So all these areas, they can also link and touch with competition, and they have some different rules, and I think it's very important that we remain aware of these different angles, and so that well, decisions in the end can really pursue the public interest. These are a couple of very general remarks. I will be happy to go into more detail if there's questions and answers. Thank you.
Thank you. So one thing that we're going to do first, we'll all react to each other. Then I want to really bring everybody in because many of you, again, have had experiences in one or more jurisdictions for which these issues have been a not insignificant amount of your time and frustration, probably. So there's one lesson that I get from the panel, which is to be careful what you wish for, because on the one hand, right, if you're a competition authority and the procedural protections are not really there, and the intellectual rigor for the substantive case is not there, don't be surprised that other jurisdictions will do exactly the same. Worse, because DG Competition is a thought leader around the world, and perhaps because of just the nature of competition law creation and systems, I would say the dominant system rather than the US. In fact, probably the most important thought leader. When there are problems on procedure and problems on substance, this emboldens jurisdictions elsewhere in the world, of which I think we've seen a number of situations, particularly in East Asia, but not exclusively so, where this has emboldened other agencies to say, but wait, this is what we're getting out of Europe and the European experience. This is what we've learned. This now justifies anything that we want to do. So what matters in Europe doesn't just stay in Europe. It has an effect globally. And so I go back to the title, International Antitrust Development's Impact on the EU. Actually, it goes in both directions. Both there's the impact on the EU and the impact of the EU on everywhere else in the world. Paul, and maybe we could start with you and just sort of go down general reactions of what you have.
Well, whether we like it or not, the Commission is a very important agency in the international competition constellation. And again, as I said, there are things that you can legitimately be concerned about if it comes to the Commission. There's no, I don't deny that at all. Now, but there are other issues elsewhere. So, but then the question for me is, if the Commission is a thought leader, what is it then precisely that the Commission should be doing? Because we might ask the Commission to reach out to their counterparties in, well, some formerly Soviet Union republic, or any other agency where something is going wrong, but there are no mechanisms to make that happen. And essentially we're dependent, or the business community is dependent on whether the Commission takes an issue with this particular matter. And it helps if the company is European, and there are a couple of other factors. But the truth of the matter is that there is no way of forcing the Commission to reach out. And let's try to take a step one step further. Because there are due process concerns in Europe, that really also affects the ability of the Commission to do so. So if the Commission would step up its own due process, respect for due process, then that would also favorably reflect on its negotiating position in relation to these other agencies. But my real concern is isn't there anything that we can come up with that would put a little bit of discipline on the Commission to actually do something and not to, well, have a meeting with the Commission and then hope for the best?
I think that the European Commission system of enforcement has the quality for competition authorities around the world of simplicity and convenience. Simplicity in the sense that the authority is doing everything. We've so many times heard that the Commission is the investigator, the prosecutor, the judge, and the jury. Well, that is attractive for any administration which is beginning to apply the rules. It's not only about making a follow on the track on substance that the European Commission may be actually making. It's also that the Commission procedures do also have an influence, and they've been terribly successful. If you look into what many countries have done, very differently from the United States. In the United States, you have judges, who are involved from the very beginning. In Europe and in continental European systems, it's different. It's the authority, and then judges look into what the authority has done up to the moment of imposing fines. So there is always a decision that there will be eventually a full review from courts, just to save the problem of Article 6 of the European Convention of Human Rights, Menarini. But the deed is done. The decision is there. The publicity is there. So I would say that the fact that it's more convenient, that it's simpler, makes that the European standard is favored by any administration entering into antitrust law. And that has as a consequence that if the authorities who are actually following the Commission follow not the latest developments, but the original way the Commission was applying Regulation 17 in the 60s, you may have less rights that you could otherwise have. And definitely, as I said before, there has been an evolution of the European Commission's procedures, a very substantive enhancement of the way parties are heard and the way respondents can have access to information. But of course, there is still room for improvement. I dare not say that the investigation and the decision-making will be eventually split. I don't think that's going to happen in the near future, but the standards in Europe are becoming better. Now, what happens in other jurisdictions? Well, it can be less so.
Yes, well, I was looking here at this question, what can the Commission do in relation to the outside? And again, just looking at the area that I know best. In our trade agreements, we have a small chapter often about competition. And, in the CETA agreement that just entered into force last week, the provisional application entered into force last week, there is a chapter on competition policy where parties agree to prohibit and sanction trade practices which include cartels, abusive behavior by companies, anti-competitive mergers. They engage to respect rules to ensure that they act fairly and transparently when applying their competition laws and pursuing investigations on companies. They recognize the importance of establishing a cooperation between their competition authorities. So there you certainly have a hook into what you were asking. What are the tools for the Commission to be more active in relation to third parties in the area of competition? But I certainly also know how influent it is by how much it is regarded as a reference or as an example in many of its decisions. And for instance, in this decision where we were involved in this reference to how do you define an unwilling licensee, I have certainly seen this mentioned as an example of a balanced orientation that was provided by the Commission as opposed to lines that have been followed in other countries, which seem to set the definition of an unwilling licensee too much to one or the other side, depending on the interest of if it's a licensor or a licensee. But clearly there, I think that was an example where a balanced and careful decision that was taken looking at the different interests at stake can be an international reference.
Thank you. Let me stop right now. We've had a number of interesting comments from people here on the panel. Let me see if there are any questions or comments, or even comments in the form of a question, which is actually what I tend to see most of. And there's no shame in that, by the way. From people here in the audience. Yes.
The lessons from the panel seem to be about the Commission's thought leadership and also about due process. And just combining those two, do you think there's an impact on thought leadership and or due process in the increasing use of commitments decisions as opposed to real investigation decisions?
It's a great question. I don't know.
Yes, I believe the creation of commitments under Article 9 of Regulation 1/2003 has been a discovery for national competition authorities, and I believe in some other countries outside the European Competition Network as well. And there are many authorities using that procedure. I personally am not against that procedure. It may help closing cases that do not have important implications for policy. But I agree that if it's abused, and I'm not judging whether the Commission is abusing it or not, it could lead to a lack of clarity as to the interpretation of substantive law, because as we all know, commitment decisions, in the end, are commitment decisions. There is no substance concerning Article 101 or 102. You can imply that there is something. It's very difficult to make a follow-up on a commitment decision.
I couldn't agree more with those observations, and maybe that's already built in the question. I mean, now that the Commission has embraced this new enforcement system or enforcement mechanism, other agencies which are less rigorous in their analytical framework or the application of that framework may also be tempted to apply this enforcement mechanism. One of the things that I find problematic is again the lack of due process in this commitment procedure. Now you may say, well, yeah, that's part and parcel of the fact that you're settling a matter, and so you're giving away part of your due process rights and also your appeal rights, and well, in return you get a resolution of your matter and no fine. But again, yeah, I do agree with you, or at least with the suggestion that the use of the enforcement mechanism, of this enforcement mechanism outside Europe is potentially even more problematic, because there are even greater concerns about the independency of the agency, etc.
I'll throw in yet another concern to augment what Paul has suggested. So there's commitment decision that gets treated as if it is somehow judicial precedent as well, that agencies like to throw in your face. They're like, no, but we have decisions. Here are commitments. Take it or leave it. And you don't, again, to the extent that there's holdup in this world, I think that's where you'll find it. Agencies saying, take it or leave it, and really you can't leave it. And we're ready for you to sign this when you're done, before you leave the room. And this is, I only exaggerate slightly because you've probably dealt with jurisdictions like that basically treat commitments as if they're decided law, and, in ways that frankly are not specific to your situation, where the facts are different, where sometimes even the substantive law being applied was different, but it gets treated that way, and this is the real danger. So there are many things that competition law does well, but sometimes there will be situations where agencies may be just motivated to being able to say, we have another victory, because they'll treat a commitment decision as a victory. And unfortunately, it's a short-term victory that inflicts long-term damages to the entire legal system, potentially. Connie.
Thank you. In this same respect, and maybe Luis is the one for this question. Commitment decisions, very well, Article 9, very well, but now you are aware of the opinion of the General Advocate Cocotte in the preliminary ruling in the Repsol case, in which Cocotte is asking the Court of Justice to conclude that even in presence of a commitment decision, any national judge could go, investigate, and analyze, and depart from the decision taken by the Commission. I don't know whether the master food case law will guide the court or not, but I would like to know your opinion, because if it is the case, I see the Commission and other agencies trying not to accept that, commitments as such a good tool, because it may be contested.
Unfortunately, that problem comes from the regulation. The regulation, it's clearly said that commitment decisions are not to be construed to impede that a judge or even a national competition authority decides differently. Now, in practice, it's difficult within the ECN to understand that there is a different point of view among national competition authorities, and the Commission is one competition authority dealing with those authorities. So in a sense, for national competition authorities, the problem should be solved by means of discussions within the ECN. As for judges, it's like that. Any judge can say, well, you were wrong, you're right, you can act. There's a breach of Article 101 or 102, even after a decision has been adopted. Because the decision, and we come back to the nature of the decision is about commitments. So formally, one day out of the blue, there is someone saying, Commission, I want to commit to doing this. And the Commission says, oh, wow, okay, good. I'm going to adopt this decision. There is nothing behind formally, there's nothing as a serious antitrust investigation. So there is no limit, there is no ban on having a second thought on that. So the scenario is a bit different as in Masterfood.
Apologising because I'm going to drag us back to IP for a second. With courts and arbitrators over the last couple of years increasingly making decisions as to what rates should be, do you think that changes the role of the regulator, and do you think it perhaps reduces the need for regulatory oversight or intervention into many of these disputes?
Great question. I'll actually just augment that to bring Pedro back, which is that, is there a role for the trade agency to get involved when there are aggrieved parties, let's say European parties, who say, but wait a second, what about in this jurisdiction? We have an agreement, right, to what you're getting at. So since this starts with IP, I'll start with you and then sort of work its way back.
Well, we as trade negotiators, we are certainly not lawyers for parties, or so we don't intervene in court cases. But of course, we are there, and with a lot of our partners, we have either trade committees or we have even intellectual property dialogues with a number of countries. And we will go there and raise systemic problems. If it's not so much about intervening in one, certainly a specific case before the court, we will not. But if there is a trend of decisions that either favor the national champion or that disrespect the terms of the WTO TRIPS agreement or of the bilateral agreement we have, we certainly intervene, and we discuss this and we ask for questions or comments, or our commissioner will write a letter. And ultimately, if this is continued, we have the tools of dispute settlement, of course, which the bilateral one we have never used so far. We have it in our new generation agreements. They are not that old. A few have been in place for 5-6 years. We have not yet launched a specific dispute settlement in a bilateral case, but at the WTO as well, we do it. So, yeah, in a sense, going to the level of, your question was more at deciding rates. Yes, no, well, certainly last week I was in Korea and we were discussing a lot, it's not linked with competition, but the remuneration in the area of copyright for what the bars, the commercial establishments have to pay. And then at some stage in the discussions we were asked, what do you think is a fair rate? We said, it's not to us, up to us to intervene. This has to be decided by listening to the right holders, listening to the users. And after all, intellectual property are private rights, so we would, as much as possible, leave issues like amounts in the hands of the parties.
Let me bring it back to the competition side by reframing the question, I think, slightly differently, but I think getting to the spirit, which is, if we have a number of contract cases and IP cases that are helping us to understand what the meaning of FRAND is, why is there such a fixation to have competition law intervene? Which I hope gets to the spirit of what you were asking.
I think there is a delicate balance between what courts do, and obviously courts are tasked with the enforcement of the competition rules, both European competition rules and then also their national rules in Europe at least, and what agencies are doing. In some respects, I think the European Commission is overreaching a little bit. But maybe that's not the general picture. In terms of FRAND, well, again, there are different views on the Huawei ZTE judgment, but there is also remarkable consensus that, well, you know, at least it provides us with a framework of negotiation of these licenses. You may still disagree on how precisely these licenses are structured, and there are many other points, but you know, there's a really good start for a national court to apply these rules. And you know, Unwired Planet, and there are a couple of German decisions, and then there is the, I believe, Acer Philips decision in the Netherlands. I think that those are perfectly legitimate decisions. Now, for then for the Commission to turn around and say, well, actually, we don't really like this. Well, that's not how the system of competition law is structured. I mean, competition law is there to be relied upon by private parties, by private competition companies, and their first destination point should be the court. It's not the agency that should tell us, well, this is a friend rate or this is a friend methodology. So I would be inclined to say, certainly if there is a framework that the Court of Justice has defined, then leave it to the national court to do what it essentially can do best in that particular case. We were just discussing trade, and there was one thing that you mentioned about these competition chapters in bilateral agreements, and I've always been a little bit fascinated by those chapters, because for us as competition lawyers, those are very interesting provisions, and essentially they discipline the other jurisdiction to come up with, you know, a decent competition system. How do you perceive the authoritative value of those chapters? Because there's little that a company can do to directly rely on those provisions and then to force the other country to behave well. But what is it that the Commission is looking for when it negotiates these competition chapters in these bilateral agreements?
Well, these chapters are not negotiated by my service, but by some colleagues in DG Trade, and also very closely with colleagues from DG Comp. I don't have a definitive answer for you, but I believe they go as far as the two sides are willing to go. If you think, certainly in the multilateral system, having a go at competition failed some years ago. In the bilateral one, people start by establishing principles. It's a bit of a step-by-step approach. There is clearly not a commitment on the two sides to go into binding, overly prescriptive rules. So it's true, they are, for companies themselves, they are really not directly applicable, and they will serve more as orientation, as there are all these agreements create mechanisms of annual discussion and debate. This can be discussed at the parties. Often there is at least a yearly meeting that is chaired at ministerial level, so issues can be addressed politically. It's a kind of soft law, or if you want, even diplomacy. We are not yet at the stage where parties are willing to accept binding competition provisions in trade agreements. And some people even say that we put already way too much in trade agreements. Some purists will say we should stick to tariffs and to classic trade, and certainly leave stuff like intellectual property or competition outside. You had a question? Yes.
Back to the ECN Plus proposal with respect to due process. This proposal, as you know, is going to be discussed before the European Parliament with the first report adopted beginning of October. And at present, what we can see in this directive is quite worrying, because there is only one provision on due process with no definition of the basic procedural guarantees. And as we said, so far the EC played an instrumental role on on a global, on a worldwide basis, because the EC is still one of the very best authorities with respect to due process. But if these rights are not defined in the directive, if it's only the recitals which refer to this, don't you think that this is going to lead to a race to the bottom, not only across the EU, because we know that there is a tremendous enforcement gap between all member states. At the EC Competition Day last week, a representative for the industry said that, for example, in Greece, there was no statement of objections sent to the parties. It can happen. Same in Poland. This is, of course, not the situation in other countries, such as France, Germany, and so on. But if this situation, if this risk is going to appear, if there is going to be a debate now on what is a fundamental right, is there not a risk of race to the bottom, not only in the EU, but also outside the EU, because the EU will not be in a position anymore, I would say, to fulfill its missionary role in other jurisdictions. We mentioned, we think about Asia. How can we prevent this from happening? Thank you.
The ECN Plus draft directive is made to enhance national competition authorities' powers. It's not thought to enhance due process. It's very sad. There are some issues that could be used eventually by member states to enhance specific aspects of due process, but it's mostly about giving more powers to national competition authorities within the European Union. It could be different, but that's the way it is. Now, the example of the Commission is not followed sometimes by national competition authorities in member states because they have their own administrative rules. And here we are dealing with very different national procedures for the enforcement of rules that are given to administrative authorities. And every country is bound to follow standard administrative procedures. So it's very difficult for some countries to change for a tiny part of their decisions the way they are adopted. And it's a fact that there are quite a few countries within the European Union in which the way procedures, administrative procedures, which can lead to a big fine, are handled. Now, I believe the Commission is not willing to do anything which is perceived by national competition authorities within the ECN as aggressive towards that given authority, because the way the ECN works is, for the moment, a very easygoing way. They are all dealing pretty well with each other, and that could create a problem if the Commission was the cop, the police officer, telling them what to do about their own procedures. So I think the problem is there. It is true that something could be done in the due process area, but my guess is that that's a much trickier issue than providing more powers or more independence to competition authorities within the ECN.
The industry specifically asked, we of course agree on more to empower members, to empower national competition authorities to have more investigative tools, but we need a balance, and the balance should be guarantees, more procedural guarantees. And today, these guarantees do not exist anymore and are very much at risk.
I agree with you. I mean, but I come back to a comment I made before. For any competition authority, including those in the European Union, and there are some authorities which are, which have less experience, for them it is very convenient not to be bound by strict procedural rules. So none of them is going to ask for a limitation on its own powers. And I insist those powers come from their own administrative procedures, from their own tradition. So it is something that won't happen, but there is definitely a problem there. In the end, the way to solve that, as usual, is to follow those decisions, take those authorities before judges, and eventually come to a judgment, either by the European Court of Justice or by the European Court of Human Rights, correcting those situations, correcting those abuses that may have an impact on human rights. So we have the Charter of the European Union, we have the European Convention of Human Rights. In the end, but it's long term, definitely things will clear up. It is true that the procedures could be improved pretty easily if everyone agreed that it's not only about more powers, there's a quid pro quo, a tit for tat. It's also about rights for respondents. But there are not so many concerns about the respondents, the defendants, as the Commission has for the lack of powers, the perceived lack of powers of those national competition authorities.
Can't help being on this side of the podium to play professor because I do that 5 days a week. And I can't help but call on somebody, but I'm going to do it. But I'll preface it by saying, Jorge, you are literally one of the great economists of the world. And when you talk to your colleagues, say, in the States, and you talk about the role of economic analysis helping to shape agency, decision-making, and thought process, and shaping the courts, I'm sure things have improved since the introduction of the position of chief economist, but do you sometimes feel like you're talking a different language, let's say, to some of your colleagues in the States in terms of they talk about their experiences, you talk about your experiences, or has the gap narrowed significantly such that it's almost seamless? What you get in Europe is very similar.
Merger control. So I think that the language, the sort of debate and discussions that we have when we are talking to the economists of the agencies in the US and here in Europe in merger control are very similar. That's not the case with antitrust thus far. And I think that to some extent doesn't reflect the fact that the economists here have kind of a different viewpoint than in the US about, you know, what is the optimal treatment of loyalty rebates, for example, or how to deal with IP issues. I think that to some extent has to do with the legal framework under which they operate. I think that in this respect, you can imagine that European economists welcome the Intel ruling within that it really makes clear that European competition law and Article 102 is about efficiency, is about consumer welfare, is about effects. That's the way that we read it, maybe too optimistically. And I think that that's going to change things within the Commission as well. I think that in a sense avoids or eliminates any risk that the guidance would be withdrawn, as I think that some people consider it should. It means that the economies are going to play a more significant role in the reviews of antitrust cases, and I believe that the economists at the chief economist team will be much more actively engaged in antitrust investigations than they have been thus far, and I think that that's all good. I mean, that doesn't mean that we're going to have immediately better decisions. I think that we have better decisions in merger control now that we used to have a few years ago, and I think that the contributions of my colleagues at DG Comp will be felt in due course. There are many issues that need to be clarified. I think that because economics has played a minor role in Article 102 thus far, there are many difficult economic questions that have not been tackled, for which we don't have that many guidance from the other side of the Atlantic, because there have not been that many cases in those areas. And I think that we will have lots of interesting issues to discuss, but I think that the fear that many of us had that the Intel ruling could meant that form was the only driver of decision-making in antitrust is over, and economics is back. And I think that we're happy about that.
Thank you, Danny. Thank you to all the panelists. And we are at the end of the day, so I want to thank you all for participating in today's sessions. And as we started the day by recognizing Europe's continuing role, an important role in driving future technologies, 5G, IoT driven by standards, we know that these issues are going to continue to grow at the intersection of IP and competition. And in this era of 130 plus jurisdictions with competition laws around the world, the global impact of developments in competition enforcement and policy relevant to standardization and IPR are only going to grow. So, we hope that this is the beginning of the leadership empirical, fact-based dialogue in the European context with this conference, and we're going to continue to have this on an annual basis going forward. A couple of announcements related to that. The Competition Policy International has graciously agreed to publish a special edition with proceedings from this conference. Sam Sadden and Raul Escalante are here. You can talk to them a little bit about this if you're interested, but when the CPI edition is available, we'll make it available. Please visit us at ipleadership.org for videos for all the panels from today. In a couple of weeks, they'll be online. The CPI articles, when they are available, will be present there. And we have many other articles and publications related to the topics we discussed today. Again, ipleadership.org. And now, join us for a cocktail hour immediately following this, located in the bar area next to the reception. Thank you again.